Hello, my name is Chris Cadwell, and I serve as the Director, Pool Administration for the Public Entities Pool of Ohio. I'm excited to introduce and welcome you to the second session of 2022 PEP Police Academy and Public Officials Institute webinar series. This particular webinar is the first in a two-part series in which we will focus on public records and the Open Meetings Act. Open meeting laws, also called sunshine laws, require that meetings of local government agencies be open to the public along with their decisions and records. The Ohio Open Meetings Act contains a number of rules for conducting agency meetings that must be followed in order to comply with the Act. Since the inception of PEP in 1987, PEP has always been a member-focused and member-operated group self-insurance pool. And today, we are proud that PEP serves over 580 public entities throughout the state of Ohio. PEP uses its public entity knowledge and risk specialization to offer a unique approach to member-focused services. We intend for today's webinar to provide an interesting and informative platform that will deliver valuable content for you and your public entity. During the last 35 years, PEP has been committed to extending and strengthening its member service programs in an organized and continuous effort to prevent, reduce, and decrease losses. As a strong supporter of risk management practices and procedures, our goal in conducting these educational sessions is to provide a learning opportunity that allows PEP members to become better informed on a variety of important law enforcement employment topics. To help members better understand and respond to these issues, our educational sessions are researched and developed by experts from the law firm Baker, Dublicar, Beck, Wiley, and Matthews. Having significant experience representing political subdivisions throughout Ohio, our partner firm has over 20 years representing political subdivisions in police liability defense litigation. Leading today's discussion to share their professional expertise and experience in litigation pertaining to law enforcement employment matters, we're privileged to have law partners attorney Tanya Rogers and attorney Andrea Zarko. Tanya's practice includes a diverse portfolio of clients in civil litigation, employment matters, and business development across Northeast Ohio, in both state and federal court. Tanya's primary focus is in representing a variety of political subdivisions in state and federal litigation, administrative litigation, employment matters, and contract issues. Andrea handles a wide range of civil litigation matters, including political subdivision and employment law, insurance coverage issues, personal injury claims, and appellate work, as well as cases involving contract and business dispute claims. She also specializes in research and legal writing involving complex issues in police liability and civil rights litigation. Welcome, Tanya and Andrea. Let's get started.
All right, hello, my name is Tanya Rogers. I'm here with my partner, Andrea Zarko, and we are going to be going over the Ohio Sunshine Law. This is just a primer, as we will be doing a more detailed seminar in July that will kind of get into the weeds a little bit more. Just in general, the term the Ohio Sunshine Law generally refers to the Ohio Public Records Act, which is codified in Revised Code 14943, as well as the Ohio Open Meetings Act, which is codified in Revised Code 121.22. As a general note, the Ohio Attorney General issues a really comprehensive manual every year about the Ohio Sunshine Laws. So if you have any very detailed questions, I highly recommend looking it up. You can just Google Ohio Attorney General, Ohio Sunshine Law Manual. They just released the one for 2022, and it's about 150 pages, and it has just very detailed citations for every issue if you have a question about a specific type of record or a request or anything like that. And after each section, there are a bunch of footnotes which contain different references to revised code sections, case law, or Ohio Attorney General opinions. So I will be covering the Public Records Act section, and then I will hand it off to Andrea, who will be covering the Open Meetings Act section. So when we talk about a Public Records Act, the first thing we talk about is a public record, and determining whether something is a public record requires a three-prong analysis. So a public record is a record that is kept by any public office. So for the first element of this, this three-pronged test, a record is defined down below on this slide, revised code 149.011G. The term kept by is not defined anywhere in the code, but it's been developed through Ohio Attorney General opinions as well as Ohio case law. And then public office is also defined by the Ohio Revised Code as set forth in Revised Code 149.011A. So that generally refers to any state agency or political subdivision. There are some areas where it can be a little murky whether something is a public office. We've had some cases involving like steering committees, other joint commissions between different public bodies, and it can be a little murky as to what the requirements are there. The rest of them are generally straightforward. If you are in a situation where it's unclear if you have a public agency or if you're part of a public agency, I would talk to either your retained attorney or your prosecutor to see what your record keeping responsibilities are. So as I indicated, the first part of this three-prong analysis is whether you have a record in the first instance. So a record is any document, device, or item, regardless of the physical form, that includes any kind of electronic record. And so the difficulty here is that a record can include pretty much anything. It can include a text message, an email, data on computers. And so with digital technology that we have, the scope of records has expanded significantly. The second prong of determining whether something is a record is whether it was created, received by, or comes under the jurisdiction of a public office. And then the third element of determining whether something is a record is whether it serves to document the organization, functions, policies, decisions, procedures, operations, or other activities of the office. So a record, as I indicated, a record can exist in nearly any format. Traditionally, when we think of public records, we think of paper, we think of public minutes, we think of correspondence to and from public officials that is in written form. But what we've learned over the years and with the expansion of technology use is that records come in all shapes and sizes. A record can be an audio recording, it can be a video, like I said, it can be a text message or an email. And what's also important to know about a record, and we'll get into this in the second element of the created, received by, or under the jurisdiction, is that it doesn't actually have to be in the public body's physical possession to constitute being a record. I have referenced here an Ohio Attorney General opinion. This is actually reference to the manual, that it essentially can be taking any form. And so the other difficult part of this, and this comes under the second element of the definition of a record, which is that it is created, received by, or under the jurisdiction of. And so again, if you have an email from one public official to another public official about public business, that's pretty straightforward. It's in the possession of the public officials. However, the difficulty comes in when it's third parties. And so there has been case law, even in recent years, that has established that even when records are entirely maintained by third parties, they can still, in some instances, create and result in public records. And so to evaluate this, the Ohio Supreme Court has developed a three-part test, and it states that a record can fall within the jurisdiction of the public entity is if they delegate some kind of duty to a private third party, and there's a three-part test called the quasi-agency test. And so here, the three elements of that are a private entity has prepared the record in order to carry out a public office's responsibilities. The public office is able to monitor the entity's performance, and the public office has access to the records for this purpose. So this has come up in a few different scenarios. There's a lawsuit recently where a third party, a citizen asked for attorney's invoices from a township, but the township had never had possession of those invoices because they were always held by a third-party carrier. And it was ultimately determined that even though the third-party carrier created and prepared and held and maintained all those records, because it served a public body, and because in theory, the public office could have had access to the records if they had asked for it, that they constituted a public record. This theory was developed under a series of cases. One of them involved an Ohio auditor, a county auditor rather, who was overwhelmed with work. And so the county retained a private contractor to conduct some auditing work to assist the county auditor. Someone later made a records request for the third parties auditing records. The county said that they weren't public records because the county never had physical possession of the records. And it was in that case that the Ohio Supreme Court kind of refined this three-part test, indicating that that third-party contractor was preparing all of these records to carry out the county auditor's duties. The county auditor was able to monitor and had a duty to monitor this private third party. And in theory, the county auditor could have had access to any of this third party auditor's records at any time. And so those are the situations in which a document or record of some kind, which is created, received, and maintained by a third party, can still constitute a public record. It's very rare. It doesn't happen very often, but it is something to be aware of. And it's another reason to have a really solid records retention schedule. I will generally touch on that, but we're going to get into that in more detail in July. So another part of evaluating whether something is a record is whether it actually documents the activities of a public office. So just because there's correspondence between two public officials, even if they're using, official public emails of the public office, that doesn't necessarily mean it's a public record. I have an example in here. If there is an administrator who keeps, a list of birthdays to provide birthday cards to staff, that would not be a public record because it's not documenting any public business. It's purely for administrative purposes within the administrator's possession. If public employees are emailing each other about their weekend plans or what they're going to have for lunch, and they're not in any way discussing public responsibilities or public duties, just because they're two public officials or public employees does not necessarily mean that it is a public record. Note, however, that again, you have to be careful because if those emails that seemed, harmless and didn't seem to do anything with public activities, they could subsequently become public records if they became part of some kind of investigation into misconduct. On this, a few things. That notes, I don't have it on the slide here, but notes are not necessarily always a public record. That is a topic of confusion a lot. In the Ohio Attorney General Manual, they have a three-part test for determining whether a note is a public record. And it is not a public record if it is a personal paper that is used by the employee for their own convenience and is not used by other employees. And so the classic example of this is a police officer who keeps a little notebook in his or her pocket while they're doing an investigation. They then use those notes to prepare the official report, and then they throw the notes away. Those are not public records because they were never intended to officially document anything. They were purely used for the officer's own personal convenience, and none of the other police officers expect to rely on them. There was Ohio Supreme Court case on that topic. So then the second element, we were just going through the three elements that make a record within the meaning of the revised code. The second element of determining whether a public record is a public record is whether it is kept by a public office. And so this has two implications. As I indicated before, there can be situations in which a third party is keeping the record and it can still constitute a public record within the meaning of this revised code. It also indicates that you don't have to produce something that you don't have, which seems obvious, but I've had a lot of frantic calls and emails from people indicating that they don't have certain documents that, a specific, particularly like angry or anxious person is requesting and they don't know what to do. So an example would be, we had a township where a member of the public would attend every meeting, and at the very end of the meeting would email the fiscal officer and demand the minutes, and constantly state that he wanted them by the next morning. And this fiscal officer became concerned, and so she would hurriedly prepare these minutes and get them off right away. And so I finally talked to her, and so she has no duty to do that, because when he's making this request, the minutes don't yet exist. The meeting just happened. She has not yet prepared the records. And there's another point that a person requesting the records, which I'll get into in a minute, they don't have any authority to establish a deadline of when you provide it. The term is reasonable. And so in this situation, this gentleman kept demanding records be submitted by 10 a.m. the following morning. He has no legal basis to do that. So if anyone's demanding something like that, you don't have to worry about that. And so those are situations where it's not kept by because it doesn't exist, or because it hasn't been created yet, or it could be maintained by a third party, but still technically qualify as being under the jurisdiction of the public office. Another element that I'll get to in a minute with regard to records requests is that you don't have to create something that the township doesn't have or township, any public entity, doesn't have or has no intention to create. An example would be, we've had requests that someone wanted a township police department's entire history of every single promotion. Well, the police department didn't keep any specific document like that. They just had to go through employment records. And so we just provided certain employment records for however long the township had them. And then that was it. We didn't have to actually go through and create a spreadsheet of every single promotion within the department. So if it's a record that the public entity doesn't have and doesn't create or doesn't intend to create, they don't have to create it. One thing on this topic that I would like to know, and that again we'll get into in more detail when we talk about this in more detail in July, is that emails and texts are becoming a hot topic for public records requests. And it's for that reason that we highly, highly recommend that public officials do not use their own personal email for anything related to their office. And that if they have the option of using a phone provided by the public entity, that they do that. But if they are using their personal phone, to really limit any use of the phone for public business. The reason for this is because I have unfortunately had a situation in which some public officials were using their personal emails. One was using their work email. There was litigation over some legislation that became really contentious. And the plaintiffs in that situation were successful at getting the court to require these public officials to turn over their personal phones and personal computers to have all of that data scanned to see if there were any public records requests that were contained within their personal phones and their personal emails that were responsive to this particular request. And it was difficult. We of course were able to go through it and redact anything that wasn't relevant, but it was, embarrassing for them a little bit because not everything got taken out. There were some things that were really commingled between their personal opinions about certain things and public business. And so just again, highly recommend that if you are an elected official, particularly, always use the public entity's email or create your own. If you have a smaller entity that doesn't have their own emails, I've seen a lot of people just do like fiscal officer, whatever township at gmail.com, something like that, so that they're very isolated, so that you don't end up in a situation where your personal information is being commingled with public records that could then later become a topic of litigation. With regard to retention schedules, I mentioned it a second ago, and this is one that there's a lot to it, so I will get into it in a lot more detail in July when we do this again. But a public entity is required to have a retention schedule as well as a public records policy. I have here, according to the Ohio Attorney General manual, again, they have to adopt and post a public records retention policy. They have to manage and organize public records. they have to make them available for copying, and they have to ensure that they're maintained in a reasonable manner and disposed in a proper manner. One of the reasons that retention schedules are so important is because if you don't have a retention schedule, the public body cannot dispose of any public record ever. It is unlawful to do so. And so if you have a retention schedule, you can make sure that your records are cleaned out properly and retained for the appropriate amount of time. And one of the important elements for that is you can have different categories, such as you can keep certain records for a certain amount of time, 2 years for certain documents, 7 years for certain documents. But you can also have records that are determined by their utility or purpose. And so a common thing that shows up in retention schedules, particularly for texts and emails, is that they can be disposed as soon as they no longer serve any administrative value. And those kind of retention schedules are really important to have in place, particularly with the use of technology for conducting business. There are exemptions to public records. This is another topic that there's a lot to it, so we will get into it in more detail in July. Here's just some of the examples set forth in Ohio Revised Code 149.43. The key ones here, I will point to this third element, or this last element right here: records which are prohibited by state or federal law. And so there's a lot of stuff that's spelled out very clearly in Revised Code 149.43 of what you absolutely cannot disclose. But then there's some that are a little less clear. One of the big ones is right to privacy. That's one that's constantly being battled out in both Ohio courts and federal courts. But there is a right to privacy. There's a constitutionally protected right to privacy. And so if some public records contain information that is, really humiliating or damaging to a person, you may have grounds to redact that to protect their right to privacy. A common example of this is, victims of really heinous crimes. They can have their name, their depiction, anything like that redacted from any public record, so that, people can request an investigation into a certain crime, but the victim's name, depictions of what happened to the person do not have to be disclosed. Also, basically anything to do with minors should be redacted, even the name of a minor. In police reports, this comes up a lot. I would make sure you go through and redact names of any minors. Any medical information should always be redacted. And then there's new legislation that came in with regard to body cameras and dash cam cameras, video footage, and new, I mean, in the last couple of years, where if someone requests, a body cam footage or dash cam footage, if it depicts a really violent crime or depicts a minor or depicts a victim of a sexual crime, that all needs to be redacted, which can be difficult to do, but that is something you have to be aware of. So public records requests. This is probably what I deal with the most, are the actual requests or the lawsuits that result from the requests. And so the revised code kind of generally provides guidance, but there's no real set parameters for responding. So the revised code requires that you promptly respond. As I was indicating before, the person requesting cannot determine what prompt is, and prompt is not defined in the revised code. It's going to be determined by a case-by-case basis. So for example, in the example I was providing, where a member of the public constantly asks for minutes, a way to promptly provide them would be, if they're generally provided or prepared within a week, that's when they should be provided. They should be, the response or the request should be filled within a week of their request, if that's traditionally how quickly the fiscal officer prepares the minutes. Now, if I have an example here, if a request is seeking 10 years of road maintenance records, and there's a ton of records and they're not digitized, they're all kept on paper, that might take a little bit longer. That might take several weeks to respond to. And so it's just going to be a case-by-case basis, depending on the nature of the request, the extent of the request, as well as the record-keeping process of the public entity. Another requirement is that the records be available for public inspection. The public entity is required to make any public records available for inspection. This doesn't necessarily apply to computers. They cannot get access to everyone's computer if they want to look at records. But if there are paper records, they are required to be made available. And again, this has to be reasonable. The keyword here is reasonable. Again, we've had situations where someone calls and demands that they have access to all permit records at 9 p.m. on a Tuesday. We do not give them access because that's not a reasonable request. But if it's during working hours and they want to come in and look through a township's whole slew of permit requests and issued permits for 10 years, they can do that as long as, again, they're not disturbing the files and it's during reasonable business hours. Redactions. As I indicated, there are a ton of exemptions to public records. And so every time you're about to issue a records request or a responsible records request, it really needs to be reviewed closely to ensure that all information that is protected has been removed or redacted. So a common example of this, we get a lot of requests for personnel files. So we need to review that to redact any reference to social security numbers, birthdays, phone numbers, home addresses, as well as minors. A lot of times children are listed on different forms. So minors, their birthdays, everything like that should all be redacted. If you do not have someone in your entity who is well-versed in this, or if the request pertains to something that could potentially contain really sensitive information, I would recommend contacting your attorney or prosecutor just to get some advice or have them take another look at it before sending it out. If a records request comes in and the public entity is either going to deny it because the information sought is exempt, or because they don't have a responsive document, the public entity is required to explain that and explain it in a reasonable time. Example, I have an example on here. If someone requests, a personnel file, including all medical records, the response would be the redacted personnel file, and you could either put in the records or in a letter back that all medical records are exempt, so they were not provided. Another important part of the records request law is that the public entity cannot require the identity of who is requesting the information or why they're requesting it. There's a balance there. If the discovery of who's requesting it and why they're requesting it would help the person seek out specifically what information is being sought. In that situation, they can ask for a little more information, but they cannot demand to know who's requesting it and why. And also we have here that the best practice is, if feasible, to try to keep records as digitized as possible. This helps the the public entity respond quickly. But we also recommend that when responding to records requests that it be digitized and numbered so that the public entity can be clear as to what was provided. We have a lot of issues where, a really voluminous request will come in, an entity will respond, but they'll respond in paper. And then a few months later, there's a mandamus action and it's unclear exactly what was provided because it was all done in paper, so we can't prove specifically what was issued and when. And then, as I indicated, there's mandamus. If a person is aggrieved, meaning that they submitted a records request and either received no response, received a denial, or the public entity refused to comply, they could pursue a mandamus action to compel the entity to provide the requested documents. Anyone can do it, but the only person who can actually bring a lawsuit is the person who specifically made a request. So if, Bob made a request, Bob's brother can't file the lawsuit. It would have to be Bob. That would be the aggrieved person. Now, if the entity does not respond, the harm is presumed. So unlike a situation where records are destroyed, which has a different definition of aggrieved person, by simply not receiving the documents, the courts presume, or rather the revised code presumes, that the requester has been harmed. And so if it is determined that a a valid records request was made. The entity did not respond at all or did not respond properly. The person requesting is entitled to statutory damages up to $1,000. So that's determined by $100 a day that the entity failed to respond. Again, that's a little difficult because it's unclear when the timeline is triggered, and it's always determined by the reasonableness of the request. And the court can vary this amount, this $1,000 amount, again, determining on whether the public entity was acting reasonably when they either denied the request or withheld certain documents. Another element of a person who is successful in a records action is they can get attorney's fees, but this is entirely discretionary of the court. The person requesting is not entitled to attorney's fees, but can get them. Again, this base is based more on the conduct of the public official and the nature of the request. Okay, we're almost to Andrea's spot, but just a few more things. I had mentioned a aggrieved person is different when records are destroyed. That is set forth in revised code. And again, I'm going to get into this more in July. I don't have it written down, I apologize. But if someone requests documents and finds out that they were unlawfully destroyed, they have to actually demonstrate they were harmed in some way to get fees. And that's under a different section of the revised code. And the reason for that is because years ago, there was a group of people who were going around requesting a bunch of documents that they knew townships had not retained properly. And then we're trying to collect a bunch of money based on it. So ultimately, the Ohio Supreme Court determined that these people were not harmed by not getting all of these different records that they knew had been destroyed improperly, but inadvertently. And so in that situation where there's an allegation that records have been destroyed, damages are based on the request and the nature of the harm resulting from the improper destruction. So now I'm going to hand it over to Andrea, who is going to handle the Open Meetings Act, and we'll go from there.
Thank you, Tanya. And now that you all know a little bit more about public records law, I am here to talk about the other part of the Ohio Sunshine Laws, which is the Open Meetings Act. Now, the purpose of Ohio Sunshine Laws are to promote transparency and openness in government, which actually really what that means is accountability on behalf of the public entities and its members. And so it's to counteract decisions that are made and that actually cannot be made in secret or in darkness, hence the term sunshine law. So these laws give all citizens the right to have access to government records and meetings. And the Ohio's Open Meetings Act, which I will often refer to as the OMA, require public officials to deliberate, discuss, and conduct business in open meetings. And so this means that if a public body is meeting to discuss and decide public business, then the meeting must be open. The OMA applies to all public bodies in Ohio. And so what is a public body? Tanya touched on that a little bit with regard to public entities that are required to provide documents. But as it applies to the OMA, it's very similar. They are decision-making groups of state or local government agencies and institutions. Your classic examples are, of course, your board of trustees, city council, Ohio school boards. Now, this also includes committees and subcommittees of a public body, even if those committees don't make a final decision. If they are any decision-making bodies, then they are subject to the OMA. And I think a good rule of thumb is that if a law or a rule requires the committee, or if a political subdivision created the committee, then it is subject to the OMA. Now, what is a meeting? which sounds like a silly question to ask, but it's the topic of quite a lot of litigation. So in order for the OMA to apply, The members of a public body must be meeting to discuss the public's business. So there are 3 requirements. A meeting must be a prearranged gathering of a majority of the members of a public body for the purpose of discussing public business. For example, if there are, well, and I've got an example right here. If 2 members of a 3-member board run into each other in a restaurant and have dinner, but they're not discussing public business, that is not a public meeting. And the other issue can be if you have a 5-member board, whether it's a school board or city council. If you have 5 members and 2 of them have met and are discussing public business, that's not necessarily a violation of the OMA. Again, it does require a majority of the members of the public body. And so let's see here. The other example we have here is if members of a 5-member board of zoning appeals decide to meet informally to review a rezone request, that would constitute a public meeting. And if it's not open and if the public does not have access to that, then that would be a violation of the OMA. Now, a meeting does not necessarily have to take place as you picture a meeting where you've got your board up in front of everybody and the public facing you. If for example, members of a public body are discussing public business via email or via text, a court probably would consider that to be a meeting subject to the standards of the OMA. So a public body could end up being liable for violations if it uses electronic communications to discuss or deliberate business outside of your traditional setting of a meeting. So, and the other thing to remember is that any communications, as Tanya stated, that are in text or email would be and would constitute a public record under the Public Records Act. A public body cannot circumvent the OMA by holding back-to-back sort of or serial meetings that are attended by fewer than a majority of its members, where they're discussing the same topics. These are called round robin meetings, and a court would likely find that is a violation of the OMA, simply because, again, and I'll refer back to the overall purpose, which is transparency. And when you're holding communications like that, then you're specifically trying to get around that, which courts do not look kindly on. Simply put, a court likes, they won't put form over substance. So if the members of a public body are meeting to discuss public business, it's likely that the court will find that it constitutes a meeting. Now, the first requirement of the Open Meetings Act is that the meeting is open. And what this means is that the Open Meetings Act gives any person the right to attend the meetings of a public body. And there are some exceptions to that, which I'll discuss in a little bit when you can have closed sessions. But the right to attend a meeting is open to everybody, not just the media. However, the right to attend a meeting does not necessarily mean that anybody has the right to participate in the meeting or to even comment. Now, oftentimes a public body will voluntarily provide time for public comment. Most people do that at the beginning, and there are certain parameters to that. However, if someone is violating the policy of the public entity, if they are becoming disruptive, the public body has the right to have that person removed from the meeting. Another way that meetings are to be open is that the members of the public body cannot vote secretly. They can't have a secret ballot. They shouldn't be whispering or texting to each other about public business during the meeting. So that is to promote the openness of the meeting in that. Now, I see we have virtual hearings here on the slide, and I will get to that in a little bit because well, I guess I'll just get to it now. Following COVID-19, public officials, of course, were permitted to hold some meetings virtually. And normally the Open Meetings Act requires members of a public body to be in person in order to be counted as part of a quorum and to deliberate, discuss, or vote on anything that is considered in the meeting. Now, again, during the early stages of the COVID-19 pandemic, the General Assembly provided a temporary statutory exception to the in-person requirement, and that allowed public bodies to meet virtually. That exception expired in June of last year, 2021. However, on February 9th, the General Assembly reinstituted a limited time exception under House Bill 51. And this, again, temporarily permits public bodies to meet virtually, and which means they can meet via teleconference, video conference, or any similar electronic means, and still have the meeting be considered in person for purposes of the OMA. And along with that, of course, any action taken during that virtual meeting would have the same effect as those taken in person. Now, this is a temporary exception, and it is set to expire July 1st of 2022, unless something changes by the General Assembly. So, and the second requirement to an open meetings to an open meeting is that the public entity provides notice. Obviously, you can't have an open meeting if people don't know that the meeting's going on. So the public bodies must provide notification to the public of when and where each meeting will take place. The law provides that each public body will establish by rule a reasonable method whereby any person may determine the time and place of all regularly scheduled meetings and the time, place, and purpose of all special meetings. So having said that, there are 3 different types of meetings that a public body can have. First, of course, is the regular one, and these are usually held at very predictable intervals, whether it's once or twice a month, on the first Tuesday of the month or whatnot. But these should be well advertised, and we suggest that there's an annual rule that is passed by the public entity setting forth when those are, and then the written rule should be at a place where the public can access it. We would recommend using technology such as a website. So if you keep a Facebook account, it's very easy, to put that rule on there, digital sign. I wouldn't rely on the newspaper as much, just because it's not as reliable. And that's more important when we get to the other meetings, which leads me to the next one, which is a special meeting. It is a special meeting is basically anything other than a regular meeting, any other kind of meeting. Public bodies must establish a reasonable method for alerting the public to the time and place of the special meeting. There's a separate requirement to allow or to inform the public of the purpose of that meeting. And this must be done at least 24 hours notice and given to media outlets that have requested such notice. But again, we would recommend that it's put on some type of, you use technology to your benefit in these types of situations. So, and the one thing that you need to remember about these special meetings is that you have to, all topics discussed must relate to the stated purpose of the special meeting. So, the same is true for an emergency meeting. And the only difference between an emergency meeting and a special meeting is that an emergency meeting is needed because of a situation that requires immediate action, where it's not feasible to allow 24 hours in advance. So in that instance, the public body must be immediately notified, as soon as practical. And then again, at the time, place, and purpose. And as with the special meeting, only topics related to the stated purpose of the meeting can be discussed. So the next requirement for open meetings are that the public body must keep full and accurate minutes of its meetings. And Tanya touched on the meetings as a public record a little bit, but their requirement of every public entity when you have a meeting. They must be promptly prepared, they must be filed, and they must be made available for public inspection. Now, these minutes do not have to be a word for word, transcript of what happened at the public meeting. However, courts have, they have started to hold a little bit about what needs to be in those meetings. And basically the gist of it is that the meeting or the minutes need to allow the public, including, and really especially including those who do not attend the meeting, to understand the decisions of the public body. And it's a little bit different after an entity has gone into an executive meeting, or they don't need to be as detailed in that sense. They only need to give a general sense of the subject matter discussed, but you still need to obviously put in the meeting minutes what the general topic was. So, and again, sort of piggybacking off of what Tanya said, the best practice really is to have these minutes in a digitized format and put on the website, or a way that allows the public to obtain these minutes, just to save yourself a headache of having to deal with public records request for the minutes, because they are, part of the rule is they must be made available to the public. So now I sort of touched on executive sessions a little bit, but I want to get into a little bit more detail about what that is. A closed door session is really another word for the name executive session. And let's see here. There we go. All right. They are and can only be initiated when a member of the public entity makes a motion for an executive session and the public body votes on it. So this motion must be made in a public meeting. You can't just convene a meeting of the public entity in an executive session. You have to have it in an open meeting, and then a motion would be made. The motion must identify the topic, and not just the topic, but it really needs to identify with the appropriate level of specificity the topic to be discussed in executive session. And then the motion must be voted on by a roll call of all the members at the meeting. Now, the session is attended only by members of the executive, or excuse me, of the public entity, but can also be attended by anybody that the entity chooses to invite. Now, there are limited exceptions to the open requirement of the OMA, which I will sort of outline here. As I said, executive sessions can only be held for a few specific purposes. The discussions and deliberations in executive session must be limited to the topic set out in the motion to adjourn into executive session. The public body cannot deviate from that topic. I know sometimes it's probably hard to do that when there's a lot of issues, but if you have more than one issue that's allowable in executive session, state that in your motion before going into executive session. So the other important issue with executive sessions is that no votes may be taken or decisions made during the executive session. You can discuss the matter, but in order to take any action or to have a vote, you need to wait until you're back into the open session of the meeting. And executive session this is an important one. Sometimes people forget that executive session is not typically confidential under the OMA. Unless there's a statutory or common law privilege or the confidentiality provisions that apply to that, any documents that are exchanged in executive session are public records. So keep that in mind. Now, typically, it's ethical for the members of the public body to keep that information, and I'm not talking about the documents exchange, but to keep the discussions confidential. However, it is not necessarily by law unless it's written out, by statute or common law. So now to get to the specific exemptions to the openness requirement of the OMA, the first allowable exemption are certain personnel matters. Now, having said that, the actual detailed issues that may be discussed in executive session are the appointment, employment, dismissal, discipline, promotion, demotion, or compensation of an employee or official, or the investigation of charges or complaints against an employee, official, licensee, or student, unless that employee or official or student requests a public hearing. In that instance, you have to have the public hearing. But those are allowed to be discussed in executive session. However, the motion cannot simply state, adjourned for personnel matters, to discuss personnel matters. As I said earlier, the motion has to be made with a certain level of specificity. So if you are talking about promoting somebody, if you're talking about disciplining somebody, say, I make a motion to adjourn into executive session for the discipline of an employee. Now, you do not need to include the name of any person to be considered in that instance. Now, the Open Meetings Act does state that investigation of charges or complaints against an employee can be heard in executive session unless that individual requests a public hearing. Now, this exemption does not apply to the discipline of an elected official for conduct related to the performance of his or her duties as an elected official. If you're going to discuss that must be done in an open meeting. All right, now the second reason to hold a closed session or executive session would be for the purchase or to discuss the purchase of property for public purposes or the sale of property at competitive bidding, which is pretty self-explanatory. The third reason is for a conference with the public entity's attorney to discuss matters which are the subject of pending or imminent court action. The attorneys or the public entity's attorney must be present during this executive session held for this purpose. Now, there's quite a bit of litigation surrounding this particular exemption to the Open Meetings Act. And what courts have held, and not the Supreme Court, but different courts of appeals have held that essentially this has carved out an exception to an attorney-client privilege. So as it stands right now, you cannot go into executive session with your attorney unless it is to discuss matters which are the subject of pending or imminent court action. And again, when you are when the public entity is preparing minutes, you need to pay attention to the wording of those minutes. And again, it doesn't need to be verbatim, but the motion should specifically state that this is the particular reason you're going into that executive session. And it should state that your attorney is present and that it is for the subject of pending or imminent court action. Let's see, the fourth reason here is preparing for, conducting, or reviewing negotiations or bargaining sessions with employees concerning their compensation or other terms and conditions of their employment. So, which, are collective bargaining matters. And then the fifth one are matters required to be kept confidential by federal law or regulations or state statutes. So that last part is sort of important. There are a lot of issues that, the public body may want to keep confidential. They may think it should be confidential, but unless it is outlined by federal law, but which, can be statutory or regulatory or by a state statute, it's not appropriate for executive session. Number 6, the details of security arrangements, which is obviously for the safety of the places that you are discussing these security arrangements for. Number 7 involves matters involving trade secrets in connection with local hospitals. And there really is not a lot of case law on that issue. Now, the final issue carved out in the OMA for executive sessions, it has to deal with confidential information related to economic development assistance. Specifically, it has to relate to the marketing plans, the specific business strategy, the production techniques, trade secrets, or personal financial statements of an applicant for economic development assistance, or related to the negotiations with other political subdivisions regarding requests for economic development assistance. Now, in order to go into executive session for this particular reason, the information, it must be found and determined by the public entity that information is directly related to the request for economic development assistance, or it involves public infrastructure improvements or the extension of utility services that are directly related to an economic development project. And it's a very tricky statutory language, quite honestly, that you must follow. So I would recommend that if your board wants to go into executive session to discuss this issue with regard to economic development, that you contact your attorney or prosecutor beforehand, just to make sure it is appropriate, and that you do it the correct way, because not only do you have to determine the issues that I set forth, but it also has to be determined by a unanimous quorum of the members by roll call vote that the executive session is necessary to protect the interests of the applicant or the possible investment or expenditure of public funds to be made in connection with the economic development project. So as you can tell, it's fairly complex and complicated. So again, I would recommend getting some assistance in that area if you choose to, or if you need to discuss economic development. There is another, there's another matter carved out here, and it's not necessarily under 121.22G, which is the subsection for executive sessions, but the Veterans Service Commission applications, they are can be held in a closed session, not open to the public. So now those are a lot of rules to have, an open meeting, and so I do want to discuss violations of those, just so everybody is aware of what can happen if these rules are violated. Now, Tanya talked about an aggrieved person with regard to public records. In contrast, for a suit to be brought under the OMA, any citizen can do so. Any person at all. This can be somebody who has gone to a public meeting and thought that some of the rules weren't followed. This can be someone who thought that executive session was held improperly for their employment, for their dismissal, anything like that. Or it can be somebody who has obtained minutes from a meeting and believed that maybe something wasn't, done right at the meeting, or the minutes don't reflect what was done at the meeting. So again, any person that believes a public body has violated the Open Meetings Act may file an injunctive action in the Common Pleas Court, and to ask the court to compel the public body to obey the act. Now, if an injunction is issued, a public body must, number one, correct the action, and then they can be ordered to pay court costs and pay a fine of $500 in an action. And that there is some pending litigation right now before the Ohio Supreme Court with regard to whether it's a $500 fine for every violation that was found, or whether an injunction needs to be found for every violation. So that's a little bit up in the air right now. But we will pay attention to that, and maybe hopefully in July, when we talk about the sunshine laws again, I can give you an update as to where that stands. Now, any action that is taken by a public body while that body is in violation of the Open Meetings Act is invalid. Now, a way to correct that is to rehold the meeting, do it over again, and do it in compliance with the OMA. So, and most of the times that is a viable option. A member, one of the parts of the OMA that has a little bit of bite is that any member of the public body who violates an injunction, now not necessarily violates the OMA, but if it has gone through the court system and a court has issued an injunction, then any member who violates that injunction may be subject to court action removing that official from office. So it's imperative that you not only obviously do your best to follow the mandates of the OMA, but then to absolutely follow any injunction that would require compliance with any section of the OMA. Now, and we have here basically, and I sort of touched on this, the best practice is if a public entity learns that it improperly conducted a public meeting, such as inadvertently failing to properly issue a notice, let's say, and then the meeting should reconsider and revote. That's the other thing. You would have to revote on all the issues discussed during that meeting. So that is what we have this month for the OMA, except for the fact that I'm also wanted to talk about, well, no, I did talk about the civil forfeiture and attorney fees here. I just got a little ahead of the section here. You should be aware, though, that if a public entity is found to have violated the OMA, then a successful complainant can be awarded attorney's fees. That's within the discretion of the court, and there are certain parameters that the court must find in order to issue attorney's fees. But and even the violation, the award is $500. Those attorney's fees can add up very, very quickly because as you all know, litigation is not a cheap endeavor.
We want to thank both Tanya and Andrea for their time in preparing and presenting this educational forum. If you'd like to learn more about PEP's comprehensive coverage towards law enforcement and employment issues, as well as find access to the associated resources available to PEP members, please visit our website at pepohio.org. Here you can also access the 2022 PEP Police Academy and Public Officials Institute Training Catalog to preview upcoming topics and webinar content, as well as learn more about PEP and the host of member services available to your entity. Finally, whether you're one of PEP's long-term members or just recently joined the pool, the PEP Board of Directors would like to thank you for your ongoing commitment and support.